a member of our education committee, and she will introduce Carol. Good morning, Kate. Good afternoon, Kate.
Good afternoon, Anne. Thank you for that. Yes, I'm Kate Mignani. I'm an attorney with Edrington, Shermer, and Murphy law firm in Pleasant Hill. And as Anne said, I am on the education committee of the Contra Costa County Bar Association. And our committee puts on these types of programs because we sensed that this was a need in our community, in the county, that attorneys wanted. And you are in for a real treat today. This is the next in a continuing series on attorneys behaving. And our featured guest is Carol Langford from the law offices of Carol Langford. She received her JD from the University of San Francisco School of Law. And she is here today, as you are likely well aware, to discuss the new rules of professional conduct 2 years later, new ethics opinions, and the Provisional Licensing Program. She's also going to look to the future of the California Bar exam, and an attorney's obligation in the post-pandemic era. I really hope you had a chance to read her very impressive bio. I am not going to take up any of her time going through all of her accomplishments, but I do want to highlight that Carol has many years of experience. She's received numerous awards and honors. She has been a national expert witness on the ethical conduct of attorneys. And I think most importantly for today's session, she defends lawyers before the state bar, and she provides valuable related advice. And so with that, Carol, I would like to turn it over to you. Welcome.
Thank you very much, Kate. All right, so let's start by talking about some issues that the bar is starting to see. Just a reminder to be very careful about trust account scams, which are coming back even greater than they ever have. And, they used to be from, Nigeria or wherever. So you'd automatically say, well, maybe I got to be careful about this email. But now they're coming from within California and from other states. So lawyers are less careful about opening up the emails. They think they might have a new client. And so you have to be even more careful. The same thing is going on with them sending a settlement check. And then you get the settlement check and they say, you put it in your trust account because they'll hire you on a civil dispute and then say it's settled. Oh, sorry, it's settled. Then you have to put it in your trust account. Then you write them a check. And of course, the original check you got is no good. So the funds, they've stolen money from you. That has been happening more and more. So you just have to be really careful with, people you don't know, and the settlement check comes because there's a strong likelihood it's probably not a real check. I even got one from Norton LifeLock, and it looked so real. It was an email, and they said, we're going to charge your account X amount for Norton LifeLock. And I said, I don't have Norton LifeLock. And they wanted to get into my computer, and that's when I stopped. So it just looks so real. I almost let them into my computer. So you got to be careful. They're becoming stronger. Also, there's identity theft now happening among lawyers, and it could happen to you. And so what they do is someone will call you from Utah and say, I gave you money for a timeshare. You were supposed to hold it in escrow or in your trust account. And the lawyer says, I don't know what you're talking about. I don't do timeshares and I've never met you. That's somebody stealing your identity, your name as a lawyer, and they take the funds. And so that has happened too. And if that happens, what you're supposed to do is you are supposed to contact the State Bar's Office of Attorney Regulation and Consumer Resources, and you tell them what's going on. They will flag your file so that they don't start prosecuting you, because the bar can prosecute you for that. If someone complains that you took their money. You also have to file a formal unauthorized practice of law complaint with the state bar. and they have those online, 1 page long, and you file a police report, and maybe one with the U.S. Postal Inspection Service and the Federal Trade Commission if fraud is evident. So you're going to have to go through those steps so that the bar doesn't think that it's you that's doing it. So just know that that's also a new one going around. We're going through a lot of changes at the bar. The bar is really changing, and not just because of COVID, because of artificial intelligence, and there's just many, many things that are promoting change in the bar. They are changing now the requirements for MCLE, and they're only changing the bias requirement. And this was actually legislation from 2019, pre-COVID. So what they're going to do is have a requirement for 2 units for bias. It used to be 1. It's not going to change your overall total, but it's going to be 2 units for bias. And one of the units has to be in implicit bias as opposed to explicit. Because honestly, in the Bay Area in California, you're not going to see people explicitly biased saying racial comments. I mean, you do, but not, you don't see a lot of that. It's more implicit. For example, you'll see a law firm with 10% women and minority partners, but yet they bring in a lot of women and minority partners. So, what's happening? What is it about the firm that's not, encouraging people to stay for some reason? And so that's the kind of thing they'll be talking about. And they do have certain requirements to teach it. So you're not just going to, like in the past, get anyone to get up and teach it. They have to have either an academic background in bias or some kind of specific training. And it's in the Business and Professions Code. So that is 6070.5. So if you're a bias trainer, some of you might be, you have to look at that if you're going to be doing the training, and that will impact people for 2024. So those of you whose names come up in 2024 to have to meet MCLE requirements, it'll come up for you then. There's also been some changes in the rules of professional conduct, just a few tweaks, and that is bound to occur. Okay. I sat on the commission that wrote the rules. So I helped write the rules that came out in 2018. And it took so much work, and you can't get, rules are hard to draft because they cover every attorney in every situation, every day, every practice area, everything they're going to do. And so it's very hard to draft rules that cover all that. So we have a few tweaks, and they're really more geared to criminal law, I think, because they have to do with, it's rule 1.16, which is termination of representation and the client file. Okay. And they basically say that, you're going to have to look at the penal code if you're a criminal defense lawyer and you have things in there that might be covered by the penal code. In other words, we want people who have been jailed to be able to have access to their files, and for lawyers not to destroy important evidence that might later exonerate them. And they also put that change in rule 3.8. So, so it's saying, hey, you're going to have different obligations in these criminal cases. Now, this is important if you're a DA or you were a former DA, just so you know, DAs are getting in a lot of trouble lately, and they never used to. So their conduct was never scrutinized. And in fact, when I would have a DA client, I was always glad because, the state bar are prosecuting lawyers. So I always felt like I could probably do well. Not that they would, be biased in favor of them, but I don't know. People just didn't look into the conduct of DAs. Who's looking at them? There's no real client, right? The public's out there, and they're not really looking over the DAs. So now they are. And I've dealt with more DA complaints than I ever have in my career. Now people are actually complaining about the behavior of DAs. And that's actually a good thing, because then people are actively watching and making sure that people get a fair shot when they go to trial. So that's happening for the first time ever, really. We don't have a lot of DA discipline cases. They have to be really bad before a DA is disciplined, unlike non-DA lawyers who the conduct doesn't have to be really bad and they're disciplined. So they're getting treated more like, you know, the regular average lawyer. 1.1, which is the competence rule now, we have added in a requirement that lawyers understand technology. Now, don't worry about it, okay? Because I know you're thinking, uh-oh, I'm not so good at technology. That's okay. I'm sure you know how to use email. You know how to use Zoom. That's enough. But what it really is getting to is you have to know enough to know that if you connect at a Starbucks or an airport onto their Wi-Fi, there's a lot of bad people that, you know, surf around in the cloud trying to have access to your private emails. And if they do get that, you know, you have to then notify your client because their confidential information has been exposed. So they're really getting to that kind of issue. You don't have to know every technology. You don't have to know how to tweet or do any of that stuff. All you have to do is know how to communicate with your clients and, you know, use a basic cell phone and all that, and you're going to be fine. So don't worry about it, but it's in there just to let lawyers know. Because believe it or not, some lawyers still don't use email. That's, you know, older lawyers generally, they don't. And you have to, because that's how clients want to communicate. I don't know about you, but you know, I decorated a beautiful office and no one ever wants to come in it. They all do it by phone and email, which is shocking to me. I'm like, don't you want to meet your lawyer in person? Nope, they don't care. So that's in 1.1, and I'll talk to you about some ethics opinions on it. And then we have changes to Rule 5.4. Now, 5.4, you know, is getting to sharing fees with a non-lawyer, and that has become a huge issue with the bar. And it's a huge issue because, you know, in the past, we didn't want accounting firms and lawyers to share fees. We didn't want, you know, lawyers to be bound with non-lawyers and share fees because we didn't want non-lawyers pushing the attorney's judgment and forcing them to do what the attorney didn't think was good for the case. Because if they're non-lawyers, profit is their motive more so. More, you know, they don't care about your ethics rules because they're not bound by them. But we have to care. We have to care because we're the ones getting in trouble, right? So 5.4 was amended so that when a nonprofit gets, say, a litigation case and they give it to a private lawyer to litigate, like a class action or something. In the old days, the lawyer would get some money back and donate it all to the nonprofit, take a little for themselves, whatever, of the award, or do something like that to get around the rule. So now we say in the rule that you can, if it's a legitimate nonprofit, you're allowed to share some of the fee with them because it was happening anyway. And, you know, as long as they're a legitimate nonprofit, because really you're doing societal good by doing those cases. So that's new in 5.4. Let's see what else here. Okay. There are many new ethics opinions that are out, and they are good. It's interesting to me because sometimes COPRAC, which is the Committee on Professional Responsibility and Conduct, I chaired that committee at one time, and I used to write a lot of the opinions along with the group. Sometimes they go for years without putting out a lot, okay? But they're putting out a lot of opinions, and they are actually well written, and they are helpful opinions. So that's good for you, and they're easy for you to access. They're free. All you have to do is go on the State Bar site, ethics opinions, new opinions, and they do it by date. So just look at the, you know, newest ones and go back, and there's tons of opinions that are helpful to you. So one that I think is really a good opinion, somewhat controversial maybe, is it deals with the issue, what are a lawyer's ethical duties when advising a client regarding the use of a contract provision in a transaction with a third party that is illegal under the laws of the jurisdiction applicable to the transaction. Okay, that's kind of wordy. All they're saying is if you're writing a contract for a client and they want you to put in a provision that's illegal, can you do that? Okay. And it's opinion number 19-0003. Okay. 19-0003. And what they conclude is that you have a duty not to counsel or assist a client in conduct that you know is criminal, fraudulent, or a violation of any law, rule, or ruling of a tribunal. And if you know the provision is illegal, you can't recommend that they use it. And you don't want to participate in presenting an illegal provision to a third party. So you can withdraw from representation. You don't necessarily have to if you haven't written that provision and the client wants to present it themselves. And they give, what I really like about the new opinions now, they give factual scenarios in them as hypotheticals and how the law would apply, which we never used to do as many. This is way more helpful. So they talk about lawyer knows that the provision has been found to be illegal, but advises HR to use the agreement anyway without further advice or analysis. That's a violation of Rule 1.2.1. Okay. Because you're just not doing anything. You know it's illegal. You're putting it in there. You're telling them to go use it. And then they go through various scenarios where it might not be. You might not be violating the rule. And so that's really helpful for those of you out there who sometimes get clients who want to push the envelope, right? A little too far. Then we have formal opinion number 497. And by the way, if you have any questions, you can type them in the chat and I will address them. And if I can't get to it, then you can email me after the program and I'm happy to address for you or give me a call. Now, there are American Bar Association opinions, okay? There's California opinions and ABA opinions. And so they both put out ethics opinions. And there's a new opinion, formal opinion 497. And for those of you who often get confused as to, what's a conflict of interest really? We have new rules on it. They're worded differently from the old rule. I used to like Rule 3310. It was like, to me, that was easy. Potential conflicts, actual conflicts, easy to read. Now we read more like the ABA. Okay, we talk about being materially adverse and all that, directly adverse. It's not a change from the current law. It's not supposed to be. The current law is the current law. And in fact, from what I could read, it doesn't seem like the courts want anything to be looser than it's been in the past. But what I like about this ABA opinion, not interpreting the California rule, but still helpful, it gives examples of what it means to have a conflict. So if you've ever thought to yourself, I'm really not entirely sure when I have a conflict in a business case or any kind of case, this will tell you. And they talk about, being directly adverse. Then they talk about what materially adverse might mean. And they say, well, they talk about suing or negotiating against a former client on something you worked on. Yeah, that could be a conflict. Attacking your prior work. And then they say, even if you're not directly attacking your prior work, but instead seeking to undermine that work or the result achieved for a former client, material adverseness may exist. So they go into examining a former client, like various scenarios that are going to bring up conflicts. And they talk about, waiver and confidentiality and all that. So to me, that's helpful. That's just a helpful opinion. And what's odd is the ABA has had that language a long time. We haven't. We've only had it since 2018. So they're writing a new opinion because guess what? People don't understand it, no matter how long they've had it. So the fact that they're writing an opinion like this, I find very interesting and something you might want to read. The State Bar of California is also addressing strongly, I think, impairment and mental impairment in particular by lawyers, and how lawyers deal with mental impairment with their clients. Because mental impairment is huge as we have an aging population of lawyers. I think the average age of lawyers now is like 45 or something. It's older. It's not, it skews a little older, not younger, even though we have a lot of young lawyers coming in. But that's the same with law schools, because law schools are accepting older. You don't see very often someone 22 going into law school, 23, like you used to. They're older. They go to night school and stuff. That's what I see when I teach. And so they're starting to address that issue. And, you know, that issue came up in the recent with the Girardi case out of LA, which he claims he has impairment now. But he didn't seem to have impairment when the money was being taken. So that's kind of, you know, interesting, because he did go about his life and no one saw any impairment in him. And so the question is, when does impairment start? And, you know, what do you do about that? And so the first one is opinion 13-0002, and it talks about the obligations of a lawyer for a client with diminished capacity. And it's, you know, the problem with California is, and we saw this when we were writing the rules, right? We wrote a rule on how a lawyer deals with a client with diminished capacity. We wrote it. And we sent it up to the Supreme Court because we thought, why not, right? When we did it, I said, this is never going to pass. It can't pass because we have duties of confidentiality, and they will trump any rule we try to draft. But they sent it up anyway. And it wasn't passed. Supreme Court said, nope. Why? Because we have a confidentiality rule. So what this opinion talks about, though, is it gives some practical solutions. What do you do if you do this kind of work, and you, or any kind of work, and your client suddenly has mania, or, you know, so depressed they can't respond, or what, you know, what are you going to do? And so this actually addresses that issue and talks about getting advance consent. That's an idea I hadn't really ever thought of, like the lawyer getting it from the client. You know, if you become incapacitated, I'm allowed to do X, Y, and Z on your behalf. That's, you know, that's kind of a new concept. We haven't seen that in an opinion before. Also, clients can become incapacitated not just from age. They could get in a terrible auto accident and hit their head, which can cause all kinds of behavioral changes. And so it's a great opinion for you folks that do PI work. Also helpful to you, not just wills and trusts, probate people, that kind of thing. It's for a lot of people. So I would recommend you pull that one up. And then we have, well, there's an opinion on when a prospective client has provided confidential information to an interviewing lawyer, may the interviewing lawyer disclose that information or use it to the prospective client's advantage. That's a new opinion that just came out in 2021. And it's dealing with the issue of prospective clients. You know, it's hard because I don't know about you, but my guess is you get calls all the time. And people talk to you and you're like sitting there going, okay, I can already tell this isn't a case for me. You know, and what duties do you have to those people who call you up out of the blue and you don't really want to take them? Or you do want to take them maybe, but they're prospective. They haven't retained you. And so this opinion kind of elucidates more. It's opinion number 2021-205. So that elucidates more what your duties are to prospective clients. And so they talk about getting even advanced informed consent from a prospective client so that you can be adverse to them later, which I'm always wary of these advanced consents because consent has to be informed. And how is it informed if you can't even tell them what, you know, what you're going to do to how you're going to hurt them? I just don't see how that's informed. So that can still be a problem. But the opinion does talk about that. And of course, it talks about Rule 1.18, which is the prospective client rule. And it really is a long opinion, and it gives you every opinion out there on prospective clients. So I would say that's probably a good one for you just to peruse during lunch one day and kind of see if it ever comes up for you. Then there's an opinion on a really helpful opinion on a lawyer's ethical obligations with regard to unauthorized access to client information. And in our days of phishing, and that's hacking, the pipeline hack, all the hacks, people, it's not hard to get into your email anymore, right? I go through USF, so I don't get so many of those bad emails. But the typical lawyer doesn't go through a school with a whole technology department, so it's a little easier for people to get through. And this talks about it. And surprisingly, you don't have obligations in every situation. So, which I actually think is good, because otherwise it's a full liability act for lawyers, right? You can get insurance for hacking, on your legal malpractice policy. But for example, they talk about where you lose your cell phone and you have a biometric authentication on it. That would be like mine, where I set it up on an Apple phone. You can set it up real easy, where I guess it reads my face. And so it lets me in. Then I have to put a password number. So it's like a two-factor authentication. And, I don't know. There's a part of me that thinks, why should I give them my face, right? Like, but you can give your thumb. I don't know if I want to give my thumbprint either. But I did it anyway because it just seemed like, okay, well, then nobody could ever get in it if I lost it. But what they say is that if you have that two-factor authentication, you can, of course, call Apple or set it up where your phone is shut down permanently or as long as, or whatever. And that way you don't have to worry about telling all your clients. And see, that's the key, is telling your client, hey, they read your emails, particularly for me, because I do state bar defense. I do students in admissions cases, and these people have passed, they're in trouble. There's a reason, or they've been in trouble. And so that's very private, a lot of times, information. So I have to make sure everything's protected all the time. Now, some of you might be in a less, practice that's a little less that type of thing. But that's good advice as far as the two-factor authentication. It makes it really hard for anyone to get into your phone. And then they have another situation where you leave your cell phone in a restaurant when you go out to eat. That can happen. Or you leave your purse, or your tote bag, and they put it in a locker. Nobody looks at your phone. You can tell nothing was accessed. No need to tell the clients. So, what I like about this opinion is you don't always have to tell all your clients. There are times when nobody really got access to the information, and we're not going to, make it a full liability act for lawyers because you forgot your cell phone. So I think that opinion could be really helpful to you. Before we go on to more opinions, though, I wanted to briefly talk about the provisional licensing, just so you know that it's up there, okay? And that was a huge endeavor. Okay, you all can hire provisionally licensed lawyers, so know that. What is a provisionally licensed lawyer? Well, it's somebody who maybe hasn't passed the bar, but they passed it very close. Like, say they got a 1340 instead of getting, 1440 or 20, whatever the current passage number is, but they came very close. They can be provisionally licensed and be on track to actually get a bar license. We haven't officially lowered the score, but we have lowered the score by doing that. And that can be controversial, right? I mean, because I took a 3-day bar exam. A lot of you did. It was hard. There was no lowered score, but the passage rate was higher. Now, there's been many things that have changed in law, okay, since I graduated from law school, and many of you graduated from law school. we had the big recession in 2007. And at that time, law schools were not getting applicants. Okay. Nobody wanted to go, nobody had the money. People were afraid. Okay. Law firms weren't hiring, they were firing or letting go. And so law schools dipped lower into the applicant pool than they would have normally by taking lower LSATs, lower graduating GPAs. And that directly showed itself in bar results. Now, what the schools should have done, they later realized was, okay, if we're going to dip lower, that's okay, but we're going to have remedial work done for people. We're going to have to teach them how to write. We're going to have, if they weren't English majors or legal secretaries, okay, English majors and legal secretaries and paralegals do the best in law school, at least in my classes. They always have, because they know how to write. We have to teach them how to write. We have to teach them more about taking exams. We have to make sure we have tutoring. They started that years, it took them a while. And now we're starting to see bar scores go higher. Okay. But that was a big problem for all law schools. Some law schools initially said we're not going to dip lower. And like Hastings, and they didn't. But even they suffered later in lower bar results. So now we're sitting back and saying, well, we have the pandemic, and the Supreme Court said you have to. They didn't say you have to, but you couldn't say no, right? Like, form a commission and figure out whether we should provisionally license, because students were sitting at home. They were, they couldn't leave. They couldn't go interview at law firms. They had to take a bar exam remotely and classes remotely. So, the bar and the Supreme Court knew we had to help these people. We had to help them. And so we did. And so we had to make a ton of requirements. Like, they can work for you, a provisionally licensed. If they want to be provisionally licensed, they apply to the bar. It's not hard. They just apply. I want to be provisionally licensed. They don't have to clear moral character, but they don't have access to a trust account. They're not allowed to. So, hey, a lot of people take time to clear moral character, so that's not necessarily bad. They can go in court. They have to be supervised, but that's left up to the lawyer, really. So we tried to make it easy, because we thought if we make this too hard, no one's going to do it. The form you fill out is like 1 page, 2 pages, maybe at most. I am supervising. So you just sit with them, and say, hey, you're going into court. Maybe you go to court with them a few times, and then they can do it themselves. Someone says, is provisional lawyer supervising similar, I'm looking in the chat, to supervising certified law students? I think it probably is. I mean, we don't say that, but I think it is, because I think that would be a good example, because they're still, remember, they've graduated from law school, but they're still like a law student in a way, because they've never, they've never been a lawyer. And so they're going into a law firm. So yes, it is. I think it's probably very similar, but probably a little less supervision because they graduated. I think it depends on the practice. Like, if it's unlawful detainers, and it's easy unlawful detainers, you give them real easy, and they, you do a few of them, it's 5 of them maybe. Well, then they can do the next 20 by themselves. So it just depends on, what it is, what kind of client it is. You have to tell the client, inform the client that a provisionally licensed lawyer is going to be working on their case. So what? You can, charge a little less. You don't have to pay them. There's no requirement you pay that provisionally licensed lawyer. I mean, they probably want to earn a little bit, right? These are people who need money because they're just got out of law school. But we don't make requirements we don't want to manage law firms, right? So we can't. And I say I'm not the state bar, but I mean, the bar can't do that. It's up to the lawyer who's supervising how they're going to handle it. We just want those lawyers to know that they got to do some supervision. You can't just throw the lawyer out when they don't know what they're doing. but it's very easy to hire one. And it's really up to the provisionally licensed lawyer. They have to clear moral character. They have to take the bar exam again if they've never taken it. They have to do things. So it's it's that kind of thing. And you would have to report, or the person would have to report too, if they committed a felony or that kind of thing, obviously. Um and we had a lot of debate over how much it would cost, because we really wanted people to pay if they were going to be provisionally licensed in, one of the big law firms. But then we knew a lot of people would do things like go to the public defender's office or somewhere where they're not going to get as much pay, a nonprofit. So we made the price low. It's really low. It's like $100 and something bucks or something. The state bar is pretty overwhelmed right now in moral character, because they have to clear eventually moral character. And that is huge because moral character is already backlogged. So provisional licensing has just thrown another element at them. And so, it's changing the practice of law, because it's allowing people who haven't, say they have a certain score on the bar exam, it's allowing people to become lawyers without passing the bar, on the score that they should. And that's new. We haven't done that before. The bar exam right now, there's been a commission appointed. It's a really solid, good commission of exam professionals, deans, it's all kinds of people, stakeholders, that are going to examine whether we should have a bar exam. Do I think we should have a bar exam? Yes, I do, for public safety. But the question is, what should it look like? We have a lot of different law schools in California. We have accredited ones, non-accredited ones. And, it's a real mixed bag. And I know I taught at John F. Kennedy, and that is not ABA accredited. But I will tell you, the top 20% of John F. Kennedy could go to school anywhere. I had all kinds of people, doctors. I had paralegals who were running firms, and their boss told them to get a law degree so that they could take over the practice. These were real high-end people. So, and then I taught at Berkeley, where, they're the top of America. That's a top 10 school, or at least a top 15. So, there's lots of different law schools. So taking all that into account, what people are really asking is, how often do people from non-accredited schools, or what are considered lower schools, lower level schools, get in trouble with the bar? Not much. If you look statistically, not much. So the question is, what about legal malpractice? And no one's ever done a study correlating legal malpractice cases with the school the lawyer went to. And I think that's the next step that they need to do, because that'll tell you a lot. I mean, I think discipline, not many people get disciplined, but people get sued all the time for legal malpractice, even if they're a good lawyer. So that would be interesting to see that connection. And then what else? We are talking, law schools are dealing now. This is just something overall, just so you know, law schools are dealing a lot with cheating, and undergrad schools are dealing a lot with cheating. I'm seeing a lot of cheating allegations of law students and of undergrads, and that's a new thing. I have never seen so much before. Plagiarism, because there's so many companies that will write papers for free, and the papers aren't always good, and a ton of students use it. Like, a lot of students who get their degree, probably the majority of them have cheated. So that's, that's a new thing, and that's because of the internet. Real easy to get someone to write your paper. And so teachers now are fighting that by doing, they get these tools on the internet that can look up a paper and see if it's been used before, and people get caught, right? So that's happening. The bar exam also experienced a wave of cheating because they did the first ever remote exam. They put out a whole bunch of Chapter 6 notices, which is, hey, we think you cheated on the bar exam. Most of them were no good. The student really didn't cheat. It's just very hard to do a remote exam. When you take a remote bar exam, you're not allowed to like move around your feet. You're not allowed to get up. You're not allowed to um, get out of the eye of the camera. Like, say you lean over, your pencil falls when you're filling in the holes. But I guess on the computer, maybe you type it in and maybe you want to scratch your leg, whatever. That's been going around a lot. There's been a lot of allegations of that. And so students have been caught with remote cheating. All right, so it's just been the PPL program. What do I see the future of that? Hard to know because we have to see what happens as a result of this bar exam commission. But I think we're going to have more pathways to practice law. I don't think it's going to be like it was before, where you go to law school and take a 3-day exam necessarily. I think we might have different levels, almost like, you know, a master's degree and a PhD, and the PhD is the actual law degree where you take a bar exam. But I also see certified paralegals and law students doing much more than they used to do in the past. And, you know, they say that promotes access to justice. That's highly debated. But I still see that being a big thing for people of low means. So the world is definitely changing with regard to who can practice law and how they're practicing law. What else? Let's see here. Third-party litigation funding. I wanted to talk just briefly about that. Some of you might use funders for your litigation. And people in the past never used to do that. There was no such thing really as litigation funding. Law firms put out their own money. They got loans from the bank and they funded themselves, and that could kill a firm if they didn't win, if they were a plaintiff's firm. Litigation funding is becoming more common, as are many financial internet type alternatives. And we have an ethics opinion on that just came out. It's number 2020-204, because lots of issues come up with litigation funding. Okay. And I wrote an article on it. By the way, it's cited in the opinion. I was like, hey, that's me. That's my article. That was a shock to me. I wrote an article on it because I thought it was very, that it was riddled with conflicts, because you get a contract from the funder and you pay an exorbitant interest on that money. And so there are incentives for you to settle early, which may not be to the advantage of the client. So you get your fee, you pay off the funder, but then is it advantageous to the client? See, so there's lots of things in the contract. And the opinion says basically, we don't care what's in your funding contract. Your obligations are the rules of professional conduct to be competent. And therefore, you have to follow those rules, even if you're getting in some kind of contractual battle with your funder. So that's kind of an interesting opinion, because clients can also get funding, and it puts pressure on them because the interest is exorbitant and it compounds. So, you know, that's the kind of thing that can raise real issues. Another very helpful opinion is number 2019-199. And it talks about what's a lawyer to do when a lawyer has a social media site and people post stuff on it. Like, say you have a site and someone says, I think she's a great lawyer, but that person was never been your client. And you go, well, that's kind of nice that this person is saying that. I think I'm going to leave it up because, hey, it might attract some business. Well, this opinion talks about what you do if you actually have a site that you control and you authorize and you post to, and what you do if there's just a site out there. Because sometimes groups will start a site, you know, and put your name on it. And you're like, I don't want a site here. You know, haven't you ever seen those like attorney rankings, and they have like a clock or whatever that, you know, gives you a number? And you don't care because you never go on that site. If you never go on it, you're not responsible for what's posted to it. If you don't, you know these people, you don't never go on that site. You could just type in I don't know this site. I don't post to this site. I can't verify the accuracy of any of these accolades or statements. That's it. You're done. So you're not responsible for every site out there, which is helpful for you to know that, okay? Because I think sometimes people get, you know, don't know what to think when they see a site and it talks about them. Do I have to correct the statement? It's not true. No, you don't. You're not going to get in trouble for false advertising. Um, and there's an opinion 2019-197 that talks about also, what do you do if you go out as a lawyer and you hire somebody to consult with? And that opinion is very, very helpful because there's ethics issues when you consult with somebody in the firm that the client hired, like you have your own ethics person. Say I work in your firm, or you counsel with outside counsel. And there's a difference how it's treated, whether it's inside or outside counsel. So that's a helpful opinion to anyone who's ever done that. I want to talk a little bit about discipline cases. We're in a stage now where the Bar Board of Trustees is looking at closed cases, which is not helpful to those of you who have had a bar complaint. Why? What happened? Well, things, it's up and down in the state bar, things come and go. But right now, what happened is all discipline must go to the California Supreme Court. They have to approve all discipline. Or case closings, like they know what's going on at the state bar, right? So the Supreme Court sent back like a bunch of cases and said, you need to recheck these. Oh, that's always scary for a lawyer like me who defends lawyers, because it means they're saying we're not sure these were handled properly. Maybe you should go after these lawyers. So when they did that, the Board of Trustees felt like they had to check because they're protecting the public, right? Of course they have to check. So they're now looking into cases that were previously closed. So you need to know that. And their discipline, I think, is backlogged because I have a bunch of cases where nothing has happened, like years. I mean, they're not the biggest fish in the pond, okay? Some of them. So it's no wonder they're putting them on the back burner. But this is like so far back burner that nothing's being cooked on that stove, okay? So that's kind of interesting to me. But they are going after lawyers who actually commit a violation with a trust account, for example. If there's a trust account issue, they're going to go after it. So you have to know that. And one case, Joseph Earl Martin, I thought was particularly interesting because in that case, he had a trust account that he never used. Sometimes you don't use a trust account if you don't receive settlements or advance fees. Say you use flat fees, you bill by the hour, you don't get an advance fee, you're not going to use a trust account. I rarely use a trust account, right? So I never use a trust account. So with him, he started using it for personal funds. There were no client funds in it. He just figured it's sitting there and I'm going to use it for myself because I'm not using it for clients. And he got disciplined with a public reproval because client trust accounts you must not commingle, even if you're not ripping off the client. And what's interesting about the case is the bar warned him. They said, just don't do it, okay? Take your money out. And he refused. So they went after him. And he's disciplined now with a public reproval. All he had to do was take the money out and leave it alone or shut the account. But no, he had to say no. And that's how he got in trouble, because he was violating the rules. So trust accounts are sacred, okay? You don't mix your own funds, even if there's no client trust monies in and it's never been used with client trust monies or hasn't for 5 years or 10 years or whatever. No, it's a trust account. We're seeing DUIs. We continue to see DUIs with lawyers. I would just say this about DUIs. Where you're going to see the problem with DUIs is like in the Kaplan case, Nicholas James Kaplan, Caplin, where there was an accident. So he got in an accident. That's also bad. It wasn't just a DUI where he's a little bit drunk, it's an accident. And he lied to the officers. So it wasn't even the accident because it was a minor accident, but he lied to the officers and said someone else was driving. And he got 30 days actual suspension. So he has to notify all his clients that he's been suspended, that kind of thing. It becomes way worse than had he just had a DUI. Because if you just get a DUI with a low blood alcohol level, it's not moral turpitude. It's just a DUI. Anyone can get one. You could drink a glass of wine, get in your car, drive home, and ups, there you go. But when you get in an accident, that kind of makes it a little more troubling. And you lie to the officer, that becomes moral turpitude because you're lying to the officer. Okay. And we continue to have, because of technology, lawyers engaging in business transaction with clients where they fight with the client over something and end up trying to take over the business of the client or the patents. And that always gets a complaint to the bar. So you have to be particularly careful, I think, with biotech and because biotech is starting to push its way up here. You're starting to see that. Started in San Diego, UCs are pushing it, right? Into UC Irvine and the Irvine area. Now we're starting to see it come up north. They're taking over a lot of the office space that technology companies used to have pre-COVID. And you're going to see lots of, I think, cases at the state bar where it's going to be lawyers with biotech entrepreneurs entering into agreements, because lawyers sometimes have money to invest. And then the biotech entrepreneur doesn't do what he or she is supposed to do, and the lawyer ends up taking over the business. Always a problem. So you just have to make sure that I would send the biotech person to their own lawyer. You have to make sure the agreement is right. It complies with the requirements of, when you have a business transaction with a client. So I think that's gonna be more and more. We are also seeing, before I go, interesting cases for lawyers with admissions. Now you are all admitted, okay, but it's becoming harder because you have lawyers with disabilities who seek accommodations, and the bar gives accommodations. There was a recent case, Benjamin Cohn, where how much accommodations is the bar going to give? He had lots, time and a half for every question. He could get up and stand around and walk around. He wanted a hotel room. He wanted a special, he wanted all kinds of stuff. And the bar finally said, "We're done here, man. You keep flunking it. It's not us. We've given you lots of accommodations." And so it went up to the Northern District, and basically the State Bar won because they said, "Look, you were given a lot of accommodations, and the bar doesn't have to do so much that you have 2 weeks to take the bar exam and they give you a free hotel room. They don't have to do that." But it's an interesting question of how far they have to go, because you have students asking for a lot of accommodations. I've done accommodation requests before. So it's kind of that tension between the bar and the person asking for accommodations. You're also seeing interesting questions on with admissions on mental health, because what do you do if someone had a period bout of depression? That's okay. People can be depressed. Lawyers can be depressed. They have medications for that. They can get over it. But what if it's serious? What if it's psychosis? One case, the person was a law student with psychosis. Now, I've dealt with those cases before in admissions and won. But what if it's close to the time of application for moral character? See, and this one student had that at the time he was applying for moral character, and they turned him down. And I think they should have, because I think being a lawyer is so important that you can't have a lawyer who is not, his psychosis isn't under control. We have lawyers that have schizophrenia. We have lawyers who have bipolar illness, and they do fine as long as they take their medications. So that's becoming more of an issue because, again, we're having an older law student who has had more of a past, law students with different abilities, physical and mental. And so the bar is starting to have to wade through that and say, where are we going to draw lines here? And the bar doesn't want to, they want to let people in. That's what I like about the law. We let all kinds of people in, and you can be a lawyer till you're 90 if you're competent. So it's a very forgiving, I think, business, unlike tech where you're 50 and they throw you out. Okay, we don't do that. But issues are coming up now as to how far we go. So it's right about the time to end. What I'm going to do is I am easily found, Carol Langford at clangford.com is my website. And if you want to send me an email because you think of a question later, or you want a site or whatever, I'm happy to give that to you or answer your questions. Contra Costa Bar is like my favorite bar. I really like all the people in it, and I'm happy to assist you in any way I can, and I hope you've enjoyed the presentation. Thank you very much.
There we go. Thank you, Carol, for that. That was superlative as usual. And you are our favorite ethics speaker. So
yay. Thank you.
Thanks, Kate, for attending. And everybody have a great rest of your week. And if there are any additional questions,